Hi, I'm attorney Chris Reich, and in this video I want to answer the question, why would you have to plead guilty before you can request defensive driving in an excessive speed case? So this is going to vary from court to court. A lot of courts you can just request defensive driving school, and if the court grants it, they'll give you a period of time to finish the class. Other courts, and we're seeing this in a lot of city courts, some justice courts now, the judge will require the defendant to plead guilty to the charge before requesting defensive driving school. Now, so defensive driving school it's a diversion program essentially. If you complete the class, then the charge gets dismissed. Now, what these courts are doing who are requiring a guilty plea is they say, plead guilty to the charge. We're going to do all the paperwork, do a change of plea hearing, get everything lined up. But then the court defers entry of judgment to give the defendant time to complete defensive driving school. And if you do complete defensive driving school, then the court's going to dismiss everything. If you don't complete defensive driving school, then they've already gone through all the paperwork and the process, and they just enter a guilty finding, and that's it. You're found guilty of excessive speed. I think the reason they're doing this is, from our conversations with prosecutors and judges, a lot of people who obtain defensive driving as a resolution of the criminal speed case don't actually finish the class. It's kind of unbelievable because it's a fantastic outcome, but for whatever reason, they're unable to do a 4-hour class over the course of 30 or 45 days. And if the court doesn't do this guilty plea proceeding on the front end, they have to start the case all over again and get the defendant back in there and kind of keep everything going, and it extends this case out on their calendar, and it's just unresolved. So when they require the entry of a guilty plea before asking for defensive driving, they're basically making sure that this case is going to be resolved in a couple months one way or the other, and it's going to be off their docket. But this does create problems for the defendant because you want to have a high degree of confidence that the court's going to grant you defensive driving school. And this can be where it's handy to have an attorney that's familiar with that court and with the judge and can advise you on if that's a good decision, if there's a high likelihood of success in getting that defensive driving school.